Okay, hopefully in this recording we'll finish professional responsibility outline. Or actually in section 11, other duties to the profession and the public, unauthorized practice of law. 11.1.1 must not engage or assist in unauthorized practice a lawyer is prohibited from. Practicing law in a jurisdiction where doing so violates the regulation of the legal profession in that jurisdiction, meaning a lawyer generally can't practice in a jurisdiction if they aren't licensed or if they are inactive, suspended, or disbarred. Assisting another person in the unauthorized practice of law, however, it is not unauthorized practice for a lay person to represent themselves, and a lawyer can help a lay person appear pro se. While a lawyer may delegate tasks to non-lawyer employees, the lawyer must supervise the delegated work carefully and must be ultimately responsible for the results. Examples of practicing law are appearing in judicial proceedings, engaging in settlement negotiations, providing legal advice, and drafting documents that affect substantial legal rights and obligations such as contracts, wills, and trusts. Now, there's a table here about unauthorized practice of law when professional judgment is required, and it compares permissible lay activities to impermissible lay activities. Those that are permissible are real estate broker, agent, filling in blanks on standard sales contract, lay tax advisor, preparing tax returns, estate planner, disseminating general information to the public on estate planning. Impermissible lay activities are real estate broker, agent, drafting a sales contract, lay tax advisor, counseling individuals on legal tax implications of their conduct, and estate planner, drafting wills or preparing estate plans for specific individuals. The California edition is employment of disbarred, suspended, resigned, or involuntary inactive lawyer. In addition to the prohibition on assisting with unauthorized practice above, an active lawyer, California lawyer must comply with various requirements upon engaging the services of a disbarred, suspended, resigned, or voluntarily inactive lawyer, ineligible person, in parentheses, and prohibited activities. An ineligible person cannot engage in legal consultation, negotiations, appearances on the client's behalf, handling the client's funds, or other activities that constitute the practice of law. Permitted activities. The ineligible person is allowed to engage in research, drafting, and clerical assistance. This may include direct communication with the law so long as it is limited to scheduling, billing updates, etc. The ineligible person may attend a deposition, but only for the limited purpose of providing clerical assistance to the lawyer. Written notice to state bar and clients. The lawyer must notify the state bar in writing before engaging the intelligible person, and after the person's employment is terminated. The lawyer must also provide written notice to all clients on whose matters the ineligible person will work. Rule does not apply to certain support activities if the person is employed for the sole purpose of providing support activities such as equipment, maintenance, courier or delivery services, catering, reception, typing, etc. The lawyer need not notify the state bar or clients. 11.1.2 multi-jurisdictional practice. Generally, a lawyer who is licensed to practice in one jurisdiction but not another must not 1. Open a law office in the other jurisdiction, 2. hold themselves out as practicing in the other jurisdiction, or 3. establish a systematic or continuous presence. In the other jurisdiction without becoming licensed in that jurisdiction. A, under 11.1.2, permitted temporary practice by out-of-state lawyer. An out-of-state lawyer can practice in a state on a temporary basis in any of the following situations. The lawyer associates with an active local lawyer. The lawyer obtains pro hac vice admission for a particular litigation matter. The temporary practice reasonably relates to the lawyer's home state practice, and pro hoc vice admission is not required for such practice. Lawyers from foreign countries can engage in temporary practice under similar circumstances as above, or if their services are governed primarily by international or foreign law. B. Permitted permanent practice by out-of-state lawyer. A lawyer who is admitted in another state or in a foreign jurisdiction and who is not disbarred or suspended in any jurisdiction can provide legal services, though, and through an office or other systematic and continuous presence in a different jurisdiction under the following circumstances. First, the lawyer is employed by their only client, for example, as in-house counsel. And second, the lawyer is authorized by federal or local law to practice in a restricted branch of law, for example, patent prosecution. California difference. The California rules for temporary and permanent practice are similar, but California places additional restrictions on out-of-state lawyers by practice area. For example, there are various registration dues and educational requirements for registered in-house counsel and registered legal aid attorneys. Additionally, with respect to foreign attorneys, registered foreign legal consultants are only allowed to provide advice regarding the law in the country in which they are licensed. 11.1.3 Bar admissions in disciplinary matters. Bar applicants and lawyers in connection with another person's bar application or disciplinary matter must not knowingly make a false statement of material fact in connection with the application or disciplinary matter, fail to disclose a fact necessary to correct a misapprehension known by the person to have arisen in the matter unless the information is protected by the duty of confidentiality to a client. Knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority unless the duty of confidentiality to a client prevents them from responding. And note that a bar applicant who violates this rule will be subject to discipline after they become admitted. California differences. The California rule differs as follows. It also prohibits a bar applicant from making a statement with reckless disregard as to its truth or falsity. It does not include the provision regarding failure to respond. 11.2 Professional independence. 11.2.1 Relationships with non-lawyers. The following rules are meant to limit non-lawyers' involvement in the practice of law and ensure that lawyers maintain their professional independence. A lawyer must not form a partnership or other organization with a non-lawyer if any of the organization's activities consist of the practice of law. Law firms must not be set up in such a way that a non-lawyer owns an interest of the firm, is a corporate officer or director of the firm, or has the right to direct or control a lawyer's professional judgment. A lawyer must not permit a person who recommends, employs, or pays a lawyer to render legal services for another to delegate or regulate the lawyer's professional judgment. 11.2.2 Providing law-related services. Law-related services are services that might reasonably be performed in conjunction with legal services. Examples include financial planning, accounting, trust services, real estate counseling, and tax return preparation, even though law-related services are not legal services. The ABA bar rules. ABA rules provide that a lawyer who provides law-related services is subject to the rules of professional conduct, meaning the lawyer can be disciplined for lack of communication, violation of confidentiality, and so on. With respect to these services in two situations: when the lawyer provides services under circumstances that are not distinct from their profession of legal services to clients, when the law-related services are prohibited by an entity controlled by the lawyer individually or with others. Unless the lawyer takes reasonable measures to ensure that the recipient knows that the services provided by the entity are not legal services, and that the protections the lawyer-client relationship do not apply. The takeaway here is that a lawyer who provides these services should take extra care to provide them separately and in a way that puts clients on notice of the difference between the legal services and the law-related services. Otherwise, the lawyer risks being subject to regulation by the bar concerning these law-related services. California difference. California does not have a rule for law-related services. 11.2.3 Arrangements restricting lawyers' right to practice. The following arrangements restricting a lawyer's right to practice law are prohibited. Any partnership, employment, or similar agreement restricting the lawyer's right to practice after termination of the relationship, commonly known as a non-compete agreement, except for the agreement concerning retirement benefits. A settlement agent for a client that restricts the right of the lawyer to practice law, for example, settling with the opposing party under the condition that the lawyer will never represent another client against that party again. This rule does not prohibit restrictions in an agreement for the sale of a law practice or in the agreement with a disciplinary authority. 11.3 Supervisors and subordinates. Responsibilities of subordinate lawyer. A subordinate lawyer will be responsible for clearly unethical misconduct, even if they were just following orders. However, a subordinate lawyer will not be subject for discipline for acting in accordance with the supervisor's reasonable resolution of an arguable question of professional duty. 11.3.2 Lawyer's responsibility for another's misconduct. A lawyer is subject to discipline for a disciplinary violation committed by a second lawyer or for an act of a non-lawyer that, if done by a lawyer, would violate a disciplinary duty rule. And when either of the following apply: 1, the lawyer ordered the second lawyer's or non-lawyer's misconduct or knew about it and ratified it; or 2, the lawyer was a partner or manager or had direct supervisory responsibility over the second lawyer or non-lawyer, and they knew about the misconduct at a time when its consequences could be avoided or mitigated and failed to take reasonable remedial action. 11.3.3 Partners or supervisors' duty to train and guide in ethics matters. A partner or other managing lawyer in a firm must make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all members of the firm conform to the rules of professional conduct. A lawyer with direct supervisory authority over particular lawyers has the same responsibility with respect to those lawyers. Managing and supervisory lawyers have the same duties as above with respect to non-lawyers, whether directly employed by the firm or acting as outside contractors. The lawyer must make reasonable efforts to assure that the non-lawyer's conduct is compatible with the professional obligations of the lawyer. That's the partners or supervisors' duty to train and guide in ethics matters. 11.4 Self-regulating profession, reporting misconduct. A lawyer who knows that another lawyer has violated the rules of professional conduct in such a way that it raises substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer must report the violation to the appropriate professional authority. Similarly, a lawyer who knows about a judge's violation of the Code of Judicial Conduct that raises a substantial question as to the judge's fitness as a judge must report the violation to the appropriate authority. 11.4.1 Exceptions to reporting requirement. Disclosure is not required when the information is protected by the lawyer's duty of confidentiality to a client, or the lawyer gained the information while serving as a member of an approved lawyer's assistance program that helps lawyers and judges deal with substance abuse problems. In California, California does not require a lawyer to report misconduct by another lawyer or a judge. Self-reporting requirements. Instead, California lawyers are required to report themselves to the state bar in a variety of situations, including when a lawyer is sued for malpractice 3 times in 12 months, found civilly liable for fraud, breach of fiduciary duty, or the like, sanctioned more than $1,000 except for discovery sanctions, charged with a felony, convicted of certain serious crimes, disciplined in another jurisdiction, must not inhibit disciplinary complaints. Additionally, the California Business and Professions Code provides that a lawyer must not make or seek an agreement either as a party or as a lawyer for a party that would, one, prohibit a person from reporting a professional misconduct claim or the settlement thereof, two, require a person to withdraw or refrain from cooperating with such a claim, or three, provide that the record of any civil action for professional misconduct be sealed from review by the disciplinary agency. And that's it for this recording and for the outline professional responsibility with the California differences.